Good afternoon, everyone, and thank you for joining us for today's program. I'm Andrea Terry, the Director of Learning for the Maryland State Bar Association, and our presenter today is Attorney Adam Spence. Our program is E-Signatures, the New Reality. Adam is with Spence Brierly Law Firm in Baltimore County. He's a litigator with 25 years of experience and also a frequent presenter on the use of technology in the practice of law. He actually did our first webinar for us on tools for the remote practice of law when the pandemic shutdown began in March. And we're happy to have him back today to discuss the topic of e-signatures, which has obviously taken on much greater importance during this era of social distancing and safety with in-person meetings. If you'd like to pose questions during the program, you can do so by typing them into the YouTube chat channel on your screen, or you can also email them directly to Angela Monroe at angela@msba.org, the email that is also at the bottom of your screen. And Adam will try to get to as many questions as possible during the session. We're grateful to Adam Spence for pulling together this important presentation for our MSBA audience. And with that, I will turn it over to Adam.
Your mic is still muted, Adam.
Hey, welcome. Today I'm going to present a timely subject on electronic signatures. Preparing this program, I realized that this is a pretty exciting program because it really does an interplay between law and technology, which as a presenter on technology, we don't often see if you've taken my remote working programs. So this is a little bit different, and I think it's quite exciting. There's a lot of new things happening, some of which are related to COVID. So this is what this program's about. I'm going to go through some introductory slides real fast and tell you a little bit about myself. I do a lot of trust and estate litigation over people fighting people and families. I do business disputes, and I like to say I do other uncivil matters. Because of the use of our technology, we're able to manage some pretty difficult document-intensive cases, and that's why I like technology. It allows me to compete and provide a superior service. Today, you're going to hear a lot about information on this program and how we use different technologies like EverSign and Acrobat. One of the things that I like to do when I present is provide a lot of materials. So what you're going to see if you go to my website, which is spencefirm.com, you'll see my blog post up at the top of the page, which is news, opinion, and tech. And then on the bottom right-hand side, you're going to see some links. There's a new link on there, which is it's e-signatures from A to Z. That was posted this morning. The links are good, except for one, which we're still wrapping up those materials. But this presentation will be online. The handouts on how to use EverSign and Acrobat will be online. So I certainly encourage you to take a look at those and download some of that information after the program, of course, because we want you to pay attention. So we start our Maryland State Bar Association seminars always with just a reminder about the resources that the bar is providing, particularly in the time of COVID right now. There is an update page. This one is great, free CLEs through June 30th. I mean, that is a phenomenal bargain if you know how much money CLEs cost, particularly if you're required to take 12 credits like I am in Virginia every year. It also has some member resource page. And one of the things that I would say to think about taking advantage of is the weekly, I guess it's a sort of a group session on managing under COVID, and it's managed by a social worker that is working for the State Bar. And it's a super helpful group. I've heard a lot of good things coming out of some of the organizations I've been involved with lawyers. Just the disclaimer, there's some pretty complex stuff that we're going to talk about today. I'm going to try to make it as simple as possible. By simplifying things, I don't want you to take the wrong impressions from them. So what I do want to encourage you to do is simply look at the law and make sure that what I'm saying is what you believe is correct, not what I believe is correct, although we have vetted this pretty heavily before presenting today. So we want to talk about the old reality. We had these wet ink signatures. We needed physical delivery, whether it was by scanning and emailing or by simply dropping it off. We have a lot of clients that did that in the past. And so you're seeing this physical delivery. Even if you're not physically delivering it, you're emailing it, you still have to convert it to electronic. So we were always finding that some of our clients, particularly the individuals, they don't have scanners at home. They might have to have their kids, with trust and estate litigation. The older people, in their 70s, 80s, they may not have a fax machine or a scanner, or even know how to use a computer, frankly. And they certainly don't know how to take a photo with their cell phone, which is often how we might get signatures that are wet that have been printed out. So, and certain documents are going to require wet signatures, so there's still some element of today's reality requiring wet signatures. And I would say that probably most, if not 98% of attorneys use the wet ink, and I'm glad to see the population of attorneys that we have on this page who are really interested in just stepping into this, what I call the new reality of signatures, which is ink is for tattoos. The e-signatures are 100% legally binding. They're actually required by e-filing. When we talk about attorneys using e-signature, I say that most aren't using it. That's the techniques we talk about in this course, but many attorneys have been doing e-filing. They're already signing electronically, and I suppose they know that. It's fast and simple. That's why we like it in our firm, because it's easy for our clients. It's really, we're about customer service. It's one of our key underpinnings of my firm's success is we really struggle and try very hard to ensure efficiency for our clients, that we're collaborating with them and not making their life more difficult, but by empowering them to get through their problems. And frankly, having documents e-signed is one of those ways where they can just sign it on their phone, and it makes it a lot easier, and clients are much happier. And I think you'll find that if you adopt some of these practices today. COVID-19 is obviously showing the value. We had been doing e-signatures for probably about 6 months before COVID hit. And we were ready for it when it did hit, because then as things really got difficult to sign in person, we were just in the middle of it, just having everything done, because now people can't even go in the old reality to Home Depot to fax something to us. So now we're really seeing the value of, or it's not Home Depot, Office Depot or Staples. We're just seeing a lot more value to it today under the social distancing restrictions. And every client has a mobile phone. This is really key. And, when you have a mobile phone and you're used to it, and you're searching on the web and you're doing your browsing on the web, it's just a hop, skip, and a jump to start signing documents on your mobile phone using the web. So I want to show you something. I am a tech person, as some of you may know. This is analytics, and I don't want to get too far off topic, but this is an analytics from Google Analytics that analyzes my website. So one of the things that you're going to see here is you have a desktop and a mobile use. That's 1 and 2 down on the bottom side of the page. But of the visits, 53% were using desktop, 41% were mobile. And so these are some metrics that we're really concerned about, because we want to make our websites as attorneys more user-friendly. This is actually lower. The mobile amount is lower. It was higher when COVID wasn't in effect. I think now people have more time to sit at their desktop and use their desktops. When COVID was not in effect, we found that we were at 51, 52% mobile and less for desktops. So that did change as a result of COVID, but we expect that to return to normal. And again, the emphasis on mobile use. Let's talk about the legality of electronic signatures. This is probably the one reason why lawyers do not want to adopt electronic signatures, or are reluctant to, because of concerns about, is this going to be binding? The one question we ask, and the reason I put that disclaimer at the front, is because if we make a mistake with our signatures and we e-sign a document and then we go to court and try to have it enforced, the judge may look at us and say, I don't think it's binding. I don't believe that this is applicable. The laws that are in place, both under the e-sign Act and MUITA, which is the Maryland Uniform Electronic Transactions Act, both of those are put in place specifically to alleviate those concerns, but I think there's still a level of distrust by attorneys. I guess they say, well, we think wet ink is wet ink. As somebody who deals a lot with wills and codicils that are of dubious origin, we see that wet signatures aren't always the best signatures, and they often can be forged, and there's no reason to think that they're necessarily any safer than electronic signatures. We are going to talk about wills in a little bit because there is some import on this discussion about those. So let's talk about the Federal e-Sign Act first. This is a blanket application to interstate commerce, which I think covers everything, depending on who you listen to. It states and specifically defines electronic signatures as consisting of an electronic sound. So we got a little link here, and I'm going to play a sound.
Yes.
If I click on that and I include that and embed that in a document, and they click
Yes.
that actually is a signature, and that's an acknowledgement, and it's binding. That's why you saw recently in the years past the yeses to credit card applications, which I remember a time, and maybe I'm getting older than I think I am, when they didn't do credit cards over the phone, and that really came into place. I want to say in the 2000s. There may have been another law, but I know that under the e-Sign Act, it permitted it, and now that's why you're seeing this. In addition, you have a symbol. That's your /s/ or even just this signature here. That's a Adobe generated signature. A signal could be an X. A signal could be the /s/. In federal court, you have to do /s/ Adam M. Spence. You can't just do /s/, although I think you can in state court. Don't quote me on that. You always want to look at the rules when you're signing. We just use this /s for our e-signs in any court. Or then a process, and the process can be a software click wrap, or when you're clicking on a document or on the acceptance of terms when you're installing software, or your browse wrap. Excuse me 1 second. Or your browse wrap, which is the concept of when you're browsing and you see a online, hey, we have a browser cookie policy, do you want to accept that? That's really a browse wrap policy. And then it has to be attached to or logically associated with the record. So the logically associated with, I think, it has to be on the document, or it has to be related, maybe an embedded yes clip, or on the phone call, or something that's specifically put on a document. And it has to be adopted by the person with the intent to sign. So that's why when you do these click wraps, these browse wraps, that's why they always make you scroll through and really, say, hey, this is me and I'm signing, because they want that intentionality of act to make it enforceable. One of the things about the Federal e-Sign Act is there's consumer consent and disclosure requirements. And I like to talk about the click wraps and the browse wraps, because what we see is they adopt a lot of these terms, and in fact they have to by law to be binding. So first, the consumer must affirmatively consent to the electronic transaction, not to the contract, but to the transaction itself. I agree, I will be bound by an electronic signature and agree to use electronic signatures. They can give consent online, and we talk about that, the cookie policies. Not all browse wrap is enforceable. Terms of use, and one of the reasons why is because the terms of use at the bottom of a web page, there's not a highlighted, do you agree to our terms of use? It has to be more in front of the consumer, and it has to be agreed to specifically by the consumer. It can't just be buried in the text. And again, click wrap is enforceable under that process that we talked about. The consumer consent and disclosure under Maryland Act is very similar. So you're going to see the same, you're going to see Maryland's Act basically mirroring the Federal Act. From what I can tell, it seems that the disclosures are the same and the consent is the same. So let's talk about the Maryland law, what we're referring to. It's MUITA. If there's any lawyers out there. If there's any lawyers out there that that know how to pronounce that, I'd be happy to have a pronunciation. But 46 states and DC have adopted the act. In addition, it confirms the validity of electronic signatures in Maryland, although the federal act, I think, supersedes and controls a lot of this. But then again, you have the consumer disclosure requirements. Let's talk about exemptions and exceptions. And these are really important because when you sign a document, you know, there's this discussion, and it was a heavy discussion about e-signing wills in the program on remote notarization. And that right here is specifically exempted, excuse me, from the e-signature act. And so wills, trusts, I think adoption, divorce, and certain family matters are not permitted. In addition, certain notices of eviction, notices of gas turnoff, some fundamental consumer rights that of notice are not exempted. So you can't just send an email as BG&E and say to the consumer, we're going to cut your power off. Do you understand? Yes, and suggest that that's binding. In addition to that, we have court orders that do not have to be. Again, these are exceptions and exemptions. It's not that the state can't do it. The state can adopt regulations that allow it, but at least it's exempted from that regulation and can be adopted elsewhere. So interestingly, the handling and transportation of hazardous materials is an exemption in both the state and federal law. Don't know why. It's just sort of an interesting sort of off book. Maybe there's something that is important about documentation and chain of custody and maybe a physical hand-to-hand of hazardous materials. I don't know. And the other thing is actually the Maryland Code says that the e-sign act notice requirements cannot be modified by MUITA. So Maryland does recognize the importance of the federal act inherently in its consumer disclosure requirements. So let's talk about our use as a law firm. These are just some, frankly, recent uses. We use them for all of our engagement letters now and have been doing so for about 3 or 4 months. HIPAA consent for medical records. We tested that to see if the doctors would accept it, and they have. We've gotten no pushback whatsoever for that to use those HIPAA. So we sent it for electronic signature. It gets bounced back. We forward it to the doctor, and they give us the records. We do that a lot when we need medical records and estate disputes where competency and cognitive physical decline become issues. Settlement agreements, once we reach a settlement, if we do and don't try the case, we use these. We've had numerous settlement agreements signed electronically by both our clients and opposing counsel. We're going to get into that a little bit later about opposing counsel and their client and how we deal with electronic signatures with that layered transaction of 2 different people it has to go to. We also have done settlement distribution letters. So, you know, right now you have the client come in, they sign the check or whatever they do, or, you know, the company pays it to you, but you still need to have the client sign something. We just have them e-sign our settlement distribution letter, and that's binding and it's quick and we can get things moving. Client leases and amendments. I bring this one up. This came up recently. We have one particular landlord that has 33 separate, two strip malls, but 33 separate tenants, and quite a few of them have had modifications to their leases with rent deferrals and forbearances. So we have been drafting amendments currently to allow them to sign them electronically. We have 2 other residential landlord tenants, multi-unit housing, that are using electronic signing of leases for the residential housing. It is permissible. I think it's permissible. I wrote a fairly lengthy article for one of my clients on this issue, but we know with commercial leases it is permissible, and that's a lot of what we do as well. So yeah, let me go to the next thing. The other thing that's kind of lurking here is, you know, there's a lot of laws out there on electronic signing, and most people just aren't even aware of them unless they're in that niche. And this is one of them, the Uniform Real Property Recording Act. Yeah, powers of attorney. Somebody asked about powers of attorney and are they exempt? I actually was looking at that this morning and I didn't come to an answer, but I think that the answer is that they're not testamentary, so you can do them. But you'd have to, again, look at the exemptions back here. And this really outlines it, 21-102B and C. It's really in this 102. You want to read that carefully. And if it's not exempted, it's included. Again, I think one of the things that we have some reluctance about as attorneys is, do I want to have a power of attorney electronically signed by a client and then risk having a bank not accept it once they become incompetent, you know, a durable medical power of attorney, or rather a durable power of attorney or a durable medical power of attorney, whether a bank or a healthcare provider. And so for us as attorneys, you know, we want to take the safest route. And so we have to be really cautious when we're adopting these. So with significant documents like financial powers of attorney, you might be able to try it with something that a client just needs something managed while they're away. I know, for instance, that while real estate transactions are permitted to be e-signed, banks won't accept them. Lenders won't accept them. So, you know, it's just a matter of, this area is so new, even though these laws, e-sign and MUITA, have been in effect now for 20 years, 19, 20 years. But really the technology and the adoption is just quickening now. And so it becomes really difficult to advise whether we use e-sign for really sensitive documents like powers of attorney, or, you know, certainly wills, because they're exempt. Powers of attorney may be exempt, I don't know. So I'll defer on that to take a look at the statute. So let's look at the this act. This is the Uniform Real Property Electronic Recording Act. It provides for electronic signing, recording, and notarization of documents affecting real property. It does not supersede the e-sign Act. The disclosures required by the e-sign Act. So again, the law is here in 2018, but I think if you talk to the majority of settlement companies, they're not using it. In fact, they've probably never tried it because lenders are not using this. Somebody just made a mention when we talk about court orders in the trust and estates, well, in the rules governing orphans court, everything has to be a wet ink. This is something that's bothered me when I'm involved in states, because all filings have to be signed by people who often are my clients. Potentially, a lot of them are out of state, challenging actions by somebody in state related to the decedent who passed away in state. And so these wet ink requirements on orphans court documents, yeah, it's very troubling, and it always has been, particularly now that we have MDAC with e-signing. I'm hopeful that the orphans court bench will start to consider sort of stepping into the 20th century. But again, there's always a cautious approach, particularly when we're dealing with testamentary issues and security and some other things. And we'll talk a little bit about that later, about the security and identification issues and how do we resolve those. So this was a big question. If anybody was on that Trust and Estates remote notarization program, which was wonderful for the information, you know, can remote notary docs be electronically signed? And that was a big discussion. The answer is some. And then I put in small letters, unless you're afraid of judges, and I do that jokingly, simply because, you know, again, banks, you know, won't accept some of these. At least that's what I'm being told by settlement companies. I could see, because of the nature of this, that some judges might be concerned about an electronic document that's been notarized, simply because it's so unusual. We're not seeing this in practice, rarely, if ever. But the law is clear. Let's talk about that. Under MUITA, which was done years ago, it has notarization and acknowledgement, and it actually says that you can e-sign a notary, and that's under 21-110. So it couples your e-signatures to both the signer and the notary, because remember, the signer is already on the other document where it can sign a document, and now this provides the notarial act under 21-110. The notary can e-sign. So presumably, if you have a camera like they did with the earlier presentation and what's been outlined by the governor's, the Secretary of State on remote notarization of wills, which came out under an emergency or remote notarization. Again, theoretically, you could be notarizing electronically on camera and see them click a phone and say, I'm signing the email you just sent me. And again, we have remote notarization order, which permits the remote notary for the first time. So this is really an issue that's sort of just come up, right? Because theoretically, before you'd have a notary sitting next to the guy and they'd be tapping a tablet and he's signing in front of them and and it's done. This certainly would permit that, it appears. Now you're remote. So not only is it remote, I'm watching them sign on their tablet remotely. So it's pretty wild. And I want to draw you back to our remote notary law, which I just added this to my program this morning, 18-201. 18-201 under the state government article. This is going to go into effect in 2020. They have advanced the remote notary law, some aspects of it, because of COVID under the emergency orders. So, be looking for these issues to be discussed. And I think if you read this statute, I think you'll see confirmation. There's a lot of discussion about electronic signatures. It's even a definition. So there's really an intentionality by the lawmakers to really encourage this and to move it forward. And in fact, that's some of the underlying LEDA concerns on sort of statements, is this is to encourage people to move to electronic signatures. There was a question about medical providers not providing and not taking HIPAA docs. I'd send them a copy of the statute, and I'd say you're in violation of this code. There's not like a power of attorney that you can present to a bank, and if they refuse, you have to sue them. But that's why we said we test it. And again, this is a brave new world. So if enough people are doing that, eventually the doctor's going to get it, and the doctors will start to allow this. And I think there's some confusion, and I think part of this, the Secretary of the State really needs to come out strongly with detailed information for medical providers, for notaries, for signing e-signing documents, and really come up with a policy statement so that lawyers and judges and everybody can kind of refer to. It could be, frankly, an opinion by the State Bar Ethics Committee, because is it ethical to use an e-signature? I'm not sure if that falls within that bailiwick, but it may. Yeah, so somebody also asked about the form consent to electronic signatures and transactions. So luckily, when we use these platforms that we're going to talk about later today, they all have these terms and conditions that you click, and they're going to contain the consumer consent and disclosure requirements. They're pretty careful about this. They've been in this game for a few years, if not more. And so you're going to see that under those terms and conditions. You won't necessarily see it up front. One of the disclosures that you do see, for instance, you'll see that later today, which is up front and is not buried in a small terms and conditions you agree to, but is actually specifically stated. It says, if you don't want to sign this or have concerns, contact this person. And the reason you do that is because the disclosure requirements actually say you have to give the consumer an opt-out right and instructions on how to get it signed if they opt out. So that's actually the reason we have that language. It's not simply if you have any questions, call your attorney. It's literally, you have to provide that information by law. So, and that's going to be, again, embedded within these platforms. So if you send it, and if you think about it, if you send an email to a client without using a platform and they sign it, you have issues with identity, security, and also, frankly, have you made the right disclosures? You could be in violation of the disclosure requirements if you're not saying, you don't have to sign this, but if you'd like, you can sign it. That actually is affirmative language you must use under the statutes. Let's go here. And so one of the interesting things, when I'm kind of trying to figure out what does the remote notary allow e-signing? These are two of the several providers that actually talk about, this one in particular, Ron eNotary.docs. It converts the traditional process of notarization to a complete electronic process. So using a digital signature technology. So the Secretary of State is contemplating this, and but yet, why is it so hard for us to find this idea that these are acceptable? And I think when the Notary Act comes in 2020, I think a lot of us will be more comfortable. But even SafeDocs, that's another one. It says the final bridge in total migration to digitizing document transactions that include a notary. And they can stay digital from creation to execution and return. Now, I'm not using these for my remote notarization. We just do it ourselves. But it's clear that these companies are using e-signing for notarized documents. They may have a hybrid, which is simply doing the cameras, and they have the technology for cameras, and they have the superintending person or the notary, and then you have your supervising attorney watching, and then it's just wet ink. And maybe they provide that, but I didn't go that deep, because when you review their website, they don't have information on that. They say this, and these are, again, providers from the Secretary of State. So again, this gives me a little bit more comfort to say, yeah, we can use these vendors and we can get these e-signed. But again, it's just something to think about. You got to remember, though, and is this really the answer to that question of can wills be e-signed? No, because again, the way the remote notarization works is, yes, you can remote notarize under the emergency order, but the rules about e-signatures still apply. So if you're allowed to e-sign it with a regular notary, then now you can e-sign with a remote notary. But before, remember, wills, you have to be in the person in front of them, and they still do not allow, more specifically, or at least until the emergency order, but now more specifically, wills cannot, and testamentary instruments cannot be e-signed. So there is absolutely no way that you can do that. Virginia, several other states have adopted e-sign wills. As a trust in estates litigator, I have mixed feelings, because you end up with a recording of the person, which is sometimes very helpful to me, sometimes could be hurtful. But you also have questions of authenticity and some other things that might be troublesome. So this is something the Bar Association is actually struggling with on their legislative committees to really look into these issues before we adopt a change. I want to talk about the USITA, Uniform Computer Information Act. There's all these different statutes out there, and if you Google Uniform Act, Transaction Act, you think this is the one. This is only the software, and it's only adopted by Maryland and Virginia. It's actually a uniform act. There were so many concerns over it because software makers are liable for defects. That's a big problem for software makers, but they can override it. The USITA also eliminated the first sale doctrine, which basically says if I buy Word Perfect in a software and I download it, it becomes mine. It's the first sale. Now I can sell it after I'm done with it. And so you can, now they're eliminating that through subscription plans, which are actually a license. So even though these were concerns, now with the new subscription plans, they're moving towards it anyways, because they're trying to get around states' bomb shelter rules, which were anti-USITA. So it's just some interesting things to think about. The American Bar Association actually has withdrawn its recommendation of adoption of this act, and I think Maryland may need to look at this and rescinding it, given its some concerns. But I guess the key point about that, don't confuse this with electronic signatures. This only applies to software, although it does have an element of electronic signatures. I want to talk about another issue that you want to think about, which is called digital certificate signatures. I don't want to get too far afield, because sometimes people's eyes glaze at this point, but there's this public key infrastructure, which is it's basically like it's a methodology of encryption, and it comes from my computer, where I'm issued an encryption key. It goes to the other computer, and they're given a public key, and they're able to read and determine if that's my key. I don't want to get into it too deep because it's kind of very cerebral and we don't really need to get into it, but you have to get a digital certificate from a third party. So if I go in and I want to sign something with a digital certificate, I have to go to a third party certificate provider, and Adobe actually refer you out to some if you want a digital certificate. Why do we care about it? Because it's really secure. Once you sign it, it can't be tampered with because the digital key is embedded within that document, and it really strengthens trust in that document. If it's really important, use a digital certificate. I've seen some commentators say we use this for affidavits in federal court to meet, whatever safety standard, but I think that this is a bit overkill. And I think that making it more difficult than less is a hindrance to moving forward with e-signature. So I sort of say, look at this, and a lot of the platforms that we're going to talk about actually have this embedded on their side, although not necessarily on the user side. They use a sort of a hybrid digital certificate technology. So it's already embedded, but when you hear this term, don't get too excited about it. And e-signature platforms, I call them digital signatures light. So let's move right into ethical concerns. What are we concerned about as lawyers, and what are we worried about when getting documents signed? So the first thing we care about is inadvertent or unauthorized access, and you may be required to take special security precautions when required by agreement, law, or circumstances. So a client could say, I'm subject to HIPAA, I need you to be more careful with this information. It's protected healthcare information, and you can't share it. You got to keep it locked up, whatever it is, password. Normally, though, if I'm just having a document signed, there's not a special security precaution, although I'll talk about it in a second, where there's an issue that makes it more enforceable in court. So you just have to use reasonable efforts. And basically that means don't just say, I'm going to use this one and this document tool and send them an email, or just do this without even thinking and looking and reviewing it and researching the safety of it. You're looking for things like encryption. You're looking for things like validation of email recipients, things like that. So this is a bar opinion, which is worth a read on remote working. And I think Maryland does not, as far as I can tell, and I didn't really look that hard, but because I found this and I was like, this is a fantastic opinion that I'd read about on a blog. But this is a remote working opinion, and it said, look, you need to take reasonable steps to ensure that the materials are confidential and data is protected. Backups, antivirus, things like that. And then on the secondary part is to confirm identity of clients and ensure that no lack of diminished capacity when signing. So what are appropriate safeguards to confirm identity of clients and others? Well, one of them is using the same email that you've been sending that client for months in a case on the settlement agreement. Sometimes when you meet with a client the first time and you have them sign an engagement letter, the only identity you have is their email that they just gave you, but they gave it to you, and so you can relatively assure that you've confirmed their identity. Diminished capacity is just going to go into the situation of, again, taking the steps during the interview process and the meeting process to ensure this issue before things are done. Interestingly, and this is what I mentioned a second ago, Section 21108 of MUTA provides that the act of a person can be shown in any manner, but then it says, including a showing of the efficacy of any security procedure applied to determine the person. So the efficacy of any security procedure. So what does that mean, and how does that play out for us as lawyers that are adopting e-signature platforms? Well, again, we're looking at the security procedures that we have is first we're gonna make sure it's the person. We're gonna talk to them over the phone, confirm their email, or maybe over Zoom so we can see, because phone is not nearly as the security that we like to think it is, because it could be somebody else, and that's why they always say to verify multiple ways for wire transfers. The other thing we do is we use pens, and they're super simple. So I send my email to joeclient@yahoo.com, and I talk to him over the phone. I send it to him. I say, I'm sending you a document. So I use his known email, and I say, and here's the pen. And I tell him that verbally. I'm not putting it in my email because that, again, defeats the purpose of security. I give him a pen, 5 letters, 3 letters, or numbers, whatever it is. You're going to see that later today of how easy this is. I mean, this is not difficult. It's just steps as lawyers that we need to take. So let's talk about 5 steps to start e-signing. Let's get down to it. We've established that we can do it. We've established our obligations, and now we're going to get right to it. So the first thing you need to do is know Acrobat, Adobe Acrobat. It's the gold standard for documents. We use it in all federal and state court filings. They invented the PDF. And frankly, everybody has used PDF in their lifetimes because of the free reader that's available. Right now, the current version is Acrobat DC and Reader DC. Reader is free. So right at the bottom here, I have this little this link, and actually the materials, the link will be active, but you can also get this on my blog, is Acrobat 101 for attorneys. And I think that's actually resources for small businesses. I think it's in there. It may also be in the link on the e-signatures. I think it is. But that's just going to talk a lot about the really powerful things that Adobe can do for attorneys that really is underutilized by a lot of attorneys. And I think Adobe Acrobat is one of the killer apps and probably the single most used software program in our firm besides Word and maybe the browser. So let's talk about the features of Acrobat, the pay one, and then Acrobat, the free one. So you can view, print, you can even sign DC as many as you want, but you can send 2 a month, and we'll chat about that in a second. You can annotate PDFs, you can search PDFs. Here's the differences though. You can't create PDFs without Acrobat. You can't edit PDFs. You can't convert it to Word. You can't combine. You can't compare forms. This is a big one for attorneys. So in the old day, we used to get Word forms, and we would compare them using the comparison or the review tool. Well, if you've been using Acrobat like me for the last 15, 20 years, the problem with sharing documents in Word is people don't want to give away their forms. And so they're going to put it into PDF. Well, how do I compare a PDF to a Word document or another PDF? Well, this DC just came out with a comparison feature where you can actually say, I want to look at this document versus this document, and it'll do what Word still does. But you can also protect PDFs and put some safety features, security features into it, which can be super, again, important as part of that ethical obligation. So I use Acrobat DC. I think I pay $15 a month for it. It's on a subscription plan. I think you can buy it for a couple of $100, but the way I figured it is if I bought it, and then in 3 years, I think is when you reach that cost, you just get a new one. It's kind of like, do you lease a car or do you buy the car? And it's just a matter of whether you want to stay up with the latest technology or drive the old Honda from 2010. So now we're going to move on to picking a platform. We need to pick an e-sign platform. Which one do we choose? So there's 4 factors that we really want to take a look at. The first is the amount of monthly documents you're going to use. So if you're an attorney and you're only going to send out 2 for signature a month, you know, God bless you. I hope you have a way to make money other than that, but it doesn't sound like that's a lot. I mean, we send quite a few documents every week, and we would be well beyond the 2 on the free. So you do want to focus on that. A lot of the free plans on these e-platforms are 5 documents a month. So again, not anywhere near acceptable in our firm, even for one attorney. So we're looking for unlimited. Which, believe it or not, it goes from 5 to unlimited, like infinity. So it's sort of you just have to pay to open that door. The second thing is number of users. So when we look at a platform, am I going to be using it? Is my staff member who hopefully is watching this program or will read this material that is going to prepare my contracts for signature, are they going to be using it as well as me? are other attorneys in my office. I have 4 attorneys in my office and 2 paralegals. All of us use this platform. So we needed not 6, but we needed more than, say, 3 or 4. And so the selection we chose was EverSign. It gives us 5 users with unlimited monthly documents. Then you get to cost. As a small solo, I say solo, I like to think like a solo, although I'm no longer a solo with 4 lawyers. I'm still cheap because I like to deliver efficiently to my clients and trim costs, because you don't make money spending it on excessive outside expenses, because they add up. So, you know, one of the things we look at with Acrobat is, I think it's like $40 a month and for 1 user, and EverSign is $40 a month for 5 users, and both have unlimited, but you've got 1 versus 5. DocuSign, very similar. When we look at DocuSign, that's one of the first in the game. Millions and millions of people use it. There's a name factor, just as there is with Acrobat. So if that name factor is important to you, then you pay a little bit more and you just suck it up. I don't think it's a cost that I can really pass through to my clients. That's just a cost of doing business, so I'm going to keep it low. And then you really want to look at user reviews and ease of use, because again, unless you're really like hyper technical or technologically savvy, you want something that's just simple to use. You don't want to be confused by it. I always tell people, even people who are like scared to use new technology, it's like you can't break your computer. You can't break the web. They're out there to use. You know, you might get frustrated. You might have to have somebody show you how to do it, which is one of the reasons why we do this program. But you really shouldn't let that fear stop you from doing this. You should just jump in. You can't break it. Again, there's several platforms that give you a free account. Normally when I find new technology, and there's a couple software programs we use for litigation, but I know that it's really good when it's got a 30-day free trial, and I buy it within a week. I bought the EverSign platform within a week because I realized its powerful potential for my firm. And so again, you know, I found that it was easy to use. My staff was sort of, you know, a couple of them were great about adoption. 1 or 2 was lazy until they realized how easy it was, and now our firm has fully adopted it. So you want to look at these. Here's some comparisons. It's a lot of information here. I don't want to go through too much of it, except for down here on monthly docs, 5 a month, 150, $30 in Adobe Sign. There it is, $30, but it's only 1 user. Here, professional is 5 users. So you can kind of, there's a lot of information here. $40 a month with DocuSign gives you 3 users. So 2 less than this and $10 more. So you can kind of see these. There's many out here, and these are all based on annual subscriptions versus monthly. If you're not sure the level of adoption, sign up monthly, or frankly, use the free, then try monthly. And then if you like it, go to yearly because it's cheaper. So why do we use e-sign platforms? I mean, why, Spence, why don't I just email them an encrypted Adobe document with a, you know, with a certificate or something that I can just do between me and the client? And the reason you're doing it is because of the audit trail and the proper party. So I say more binding because, again, if I send an email to my client and said, hey, here's a Word document, could you just mark X, sign it, and send it back to me as a Word document? That's binding, and it's no less binding than something signed on EverSign. It's just that if it's challenged, we have an audit trail now, and the audit trail basically says it was sent by me from this email on this date to Joe Client at this email address, who opened it at this time and this date, who signed it at this time and this date, and then it was returned to me for my client's signature, and so on and so forth. So we call that the audit trail. When you go to court, you know, as a litigator, that audit trail is going to be really important to proving the signatures and the intentionality of the adoption of the signature by the parties. So the next thing you're going to do, once you pick your platform, you're going to test and understand it and figure it out. So this is just an Acrobat introduction. I'm not going to make recommendations. You know, the Bar Association doesn't like me to get too excited about one program or another. So I've given you two today. I'm going to give you EverSign and Acrobat. But again, you kind of have to look around and poke around and see what's best for your firm. So when you do this, you go into Acrobat and you use fill and sign, and you say, well, I'm going to fill and sign it, or I'm going to request signatures. So this is kind of an interesting thing. And then once you say request signatures, you get started. So you sign it, recipients open it, the link, and then that you get notified when it signs. And then here's where you would do it, is you send in your signers right here. And then in number 4, once you enter your signer's name, you go up here and you're going to fill it out and prepare it for signature. This is just a really quick rudimentary document set for Adobe, because I'm going to focus much more detail with EverSign in a minute. And here we know it's been sent. So why is this important? This is important because the successfully sent for signature is part of that audit trail, which you will get at the end of it. And so you need to know the sending and the receiving, and that becomes important. Almost every electronic platform follows these rules. And yes, EverSign does allow you to order the document. We had a client that got, we did get an issue with that. And one of my clients was very old school, and he said, well, I don't want to sign until I get their ink. And I was like, okay, Joe client, we'll make that happen for you. And we did, and we put it in ordering, and it doesn't get emailed to them until it's been fully signed by the other people in the order. So it's pretty good. Yeah, so somebody had mentioned about the governor's order, the emergency order. There's an electronic right to sign, but I still don't believe that it authorizes electronic signing of wills and testamentary instruments. Again, I think the electronic signatures that they're talking about in the emergency order apply to other documents. And the reason why I believe that is because with the Notary Act coming into play in October of 2020, they still don't allow wills, even with electronic signing of notaries, and the documents that the notaries will be witnessing. It's a completely electronic transaction, but it still does not allow remote electronic signed wills and testamentary instruments or other certain family documents or whatever. I guess property settlement agreements. I don't do family law. It's not my cup of tea, but that would be, I guess. And again, we err on the side of caution always as attorneys. We're insurance for our clients, not a problem for them. And so we want to be more cautious, and I would certainly think to be cautious in that way. So let's understand reassignment and delegation. So one of the things you may have picked up on is it's really, and you actually will pick up on it when you start doing this, is if I send a document for signature to opposing counsel and I say, Joe, have your client sign this, the audit trail says I sent it to Joe counsel, not Jane client. And now I've got a problem, because does Joe, does the attorney open it up and sign it? No, he can't. He has to send it on to the next person to sign. And so we really have this problem. It doesn't work if it's sent solely to opposing counsel, like we might have with a settlement agreement, and then he forwards it on and does things. So we've got two problems. One is you need the audit trail. You need not opposing counsel to sign, but his client to sign. And two is I'm not allowed to communicate with party represented by counsel. So what's the solution? EverSign uses a reassign feature. DocuSign uses Manager. And from what we can tell through our limited research on this, these reassign features are standard for just about every e-sign platform. I will tell you that I reached out to EverSign, and I was concerned about this issue because I didn't know about the reassign feature because I was sending it to somebody, and I didn't realize you could reassign it on the receiving side. And when I contacted customer service, they're like, yeah, we don't have that ability. And then as I was preparing for this program and really looking at both sides of the transaction, I realized that they do in fact have a reassigned signature. DocuSign's a little different. You actually say the receiver is actually a manager. And so you assign them not as a signer, but as a manager. I think that's how that works with DocuSign. But again, effectively the same thing. The person who gets it says, this needs to go to this email for this client to sign. and it just goes two-step process. So without further ado, what everybody has probably come for, I'm going to start a live demonstration of eSign, or of EverSign. Here's the website. It's pretty easy. I'm going to log in here. And so the first thing I want to point out to you, and this is a sort of a new thing with all these apps that are floating around nowadays, whether it's Slack or Teams, I don't know about Teams, but you can, Wufoo, a form program, SurveyMonkey, is you can brand the surveys or you can brand the product. So you have to upload your logo and you have to upload certain information. But once you do that, that brand that we have, and brand is very important to us because it's fundamentally our identity and the quality that we're delivering, but it allows us to follow that brand identity, not just in our own paper letterhead and whatnot, but also now through EverSign, which gives it an imprimatur of trustworthiness with our clients and potentially with opposing counsel, because then they're like, okay, I'm familiar with that, so this looks legit. And that's really what you want is it's a trust issue. So this is my dashboard, and I'm going to go to Documents. And what I'm going to do, okay, so somebody asked if these documents, e-signing, can be used for schedules, disbursements, and releases in a final distribution, and I think so. You know, the wet signature requirement that you would have in orphans court is related to, and I say in the probate area, is related to the creation of the testamentary instrument and then the filings with the court. There's no requirement that a private release between the parties be sort of per se filed with the court as a motion or a verification. So I think you'd probably be safe doing that, because again, when they come and they say, well, I didn't release you, I'm going to sue you, you can present this waiver that they signed as a contractor with you outside of court, as it were. So I wouldn't be as reluctant to use e-signing for waivers within the orphans court arena, but provided that they're really a separate document from those proceedings, which I believe waivers are. If you are required to file it, and oftentimes orphans courts will require you, if you think about it, and this has broad applicability because you want to think about it in general, where can you use these, but orphans court requires wet signatures for everything. So if they have a concern about a claim that's been made by a beneficiary, and you have to satisfy that by submitting a release of claim, they may reject it if the release of claim is not wet ink, because every filing has to be wet ink. With that said, you know, a release of claim, worst case scenario, you get it e-signed, you file it, they bounce it, you go back to the client, and you say, you got to sign this. But I guess the worst case is you've already distributed and they won't sign it. So I think you have to be careful with that. But I think I would be more inclined to have it e-signed than less. So let me show you what this is. So this is our screen where we create a document, and you're going to see I'm going to sign it only. Maybe I'm signing something that somebody sent me. I want to have me and others sign. This might be an engagement letter, or other sign. This might be the lease agreement or amendment or settlement agreement. So, so without further ado, let me go ahead and bring up a document. This is going to be a consulting agreement between me and Bill Hall. Bill is the technological guru for the State Bar, and he is running our show today in the background. And thank you, Bill, and Shally and Andrea, or Angela. Well, it looks like Angela and Andrea, who are our core group of helpers here today. So I have created a document for Bill. And let me figure out where that is. And I had it this morning, and now it seems to be gone. There it is. Where's this puppy? Okay. So I want to show you this is actually an interesting. I'm going to show you real fast the use of Word and Acrobat in the integration, because I think, like I like to throw out quick tech tips. Here is a quick tech tip. Okay. So we can create PDFs by scanning, or we can do this. You can go over here to print, save as PDF. You can click Save As, and then when you click on that, it'll give you an option to save as PDF, or you can do what I did, which is go up here to my Customize Quick Access, and there's more commands. I'm just going to show you this real quick. You have to go into All Commands, and I don't put this in my materials, but inside of All Commands is Publish to PDF. And when you get down to it, you add it over to here, and you just click Add. And it puts it up at this top little screen, and I use this for all of the things. There's a Save As, which we use a lot instead of just Save. So I don't have to go finding, how do I print this to PDF? So I publish the PDF up here, this little button. I click it, now that it's up there, and I click Publish, and it's published. So super easy, super quick, and everybody should have that at the top of their little customized commands, quick access command toolbar. It's a nice little trick. Okay, let's go to this build all contract and figure out where this thing is. Desktop, there it is. There it is. And get rid of all that garbage. So I'm going to show you another thing here. If I go to my desktop, right here, here's the bill haul contract. So there's two ways you can choose files. You can do it the old way, which is going up here and then scrolling through and finding your bill haul contract. Or the way that I prefer is to actually find it in your file explorer. So when you notice I found it by typing in bill haul contract right there. And then I clicked search. So then what I do is I just drop it right in there. So again, what we're doing is we pick me and others. We then drop our file in here, and then I can look at it. Yep, that looks like the one I need. So I dropped it in there. Couple things about this. You'll notice I don't have dates on here. We're going to put dates on here, but because they don't actually need to fill it out, I don't think it's necessary to even put dates on there anymore because it's going to be automatic. So the signers are going to be me and Bill Hall. So I'm down here now in the signers and CCs. And once I enter his information, it's automatically remembered by EverSign in his address book because I have a Sage contact checkmarked. Now, here's the kicker. We talked about that security and that language that said other security features surrounding the transaction. So I'm going to give Bill Hall, who's watching right now, a 1, 2, 3, 4 pin. So it's now locked, and he has to have that pin to unlock it. So if Bill has a kid who gets on his computer and starts to play around with it and clicks on the email and accidentally signs it, he can't sign it because it's locked. In fact, he can't even review it, I don't think. So yeah. Yeah, so somebody asked about e-signatures. Well, I'll come back to those, the liability issues on should they be enforceable and are they safe or are they usable? So document title here, if I don't put anything in here, it actually is going to put the name of the document in. And I like that because they can see my document. And then I can put an email in here, or I have my own, you know, that I just a kind of a basic one. Here is that contract we discussed. Okay. You have down here, enable auto reminders and require all signers to sign it. So it's not like an optional thing. You can check that off and say, no. I want to show you another thing. You can see where it says CC. So I'm going to put in here Garrett. That's my partner. And I'm going to not make him a signer, but a CC. So Garrett will get notice that I've sent it out. He'll get notice that it's signed. He'll get notice that Bill's opened it, that Bill signed it, and that he'll get the final document. So I just put him in the CC. So normally I use this when I'm collaborating with one of my team members to get a document signed. Usually I assign a staff member on my files, and so we usually will CC them. So once that's done, you kind of go through here and sort of see these basic things, and it's pretty easy so far, I hope. You go back here and you've got your document. Now you need to prepare it. Don't send quick send because it doesn't have signatures yet. If you click that, it will say, do you want signatures? And you say yes, go back. You don't need to save a draft. That gets kind of goofy because then you got to go over here to documents, drafts, and find it again. You just click prepare. But before you click prepare, make sure everything is done. That's what we found is the most helpful. So I click prepare. And now here's my document. And so Bill doesn't know this yet, but he's got my service agreement for the video. He's got to read the small print, which is so small it's invisible. But he doesn't mind because he's a good sport. Oops. And he's going to sign it anyways. So what I've done there is I've clicked on these two things up here and one of the signers, and then I've put the signature block right here. It recommends that you don't change the size of the initials or the signatures. That's one field that it doesn't recommend changing. So I also need him to initial this. So that's going to go down there on the bottom right-hand side of the page. Right there, initials. Now, the other thing I want to do is once he signs it, he doesn't have to complete this. It'll automatically be completed. But I can also put the date signed up here. So signed this blank day of blank is no longer, now it's this document signed on, because this is going to auto-complete that. There's not a bunch of fields, and we actually had to modify our normal legal documents, the settlement agreements, for instance, that had the blank day of blank. We now put signed on blank just to accommodate now because it's just one date. This date will be posted by whoever signs that color. So right now it's my color, but I want Bill to sign it because he's gonna sign it second. I'm gonna sign it right now while we talk. So you'll notice when I grab this here, it's still blue. So I go up here to, well, there's two ways to deal with that. You can assign, well, it says no signer, I don't know why. It should say me. I'm going to click on this color, which is me, which is kind of nice to see. And this is one of the goofy things is I can't, if I wanted to add like, to change this signature, I find that it's hard to just click back and forth up here without just dropping it in and then clicking it. So I don't know if that made sense, but like if I click, let me just remove this. So if I'm doing Bill and I click on that, well, I guess it does work. Now, what this is doing is this is now telling me how to sign it. And there's 4 options. This is my uploaded signature. Here's the pretty signature. And you just pick one. I say, I like that one. It's pretty. You can also type your signature. I can say, Adam Spence, the tech guy, the trial lawyer. And you can also draw your signature here. If you have a pen and a tablet, it's even easier. Or you can upload, and that's how we got that uploaded signature, this one right here. It was actually not drawn. But I'm going to do this, and I'm going to sign it. And that's how I always sign, of course, my documents, and particularly the important ones with the court. I'm going to go date signed. Just drop that right there. And I'm going to initial it. And I'm going to sign that. So that's automatically going to do that. Now it's done. So what I'm going to do, we're going to actually send it out, and we're going to have Bill sign it now. He needs to sign here, and he needs to initial here. So what we're going to do is I'm going to send this. And now it's telling me what's going on with it. So I signed it on this date. It was sent on this date, and then it's CC'd to this gentleman. And these are going to become important again with our audit trail. So at this point, what we're going to do is we're going to turn over the screen to Bill Hall, who is now going to check his email and bring it up. Okay, so what Bill's going to do is Bill's not going to click on anything until I tell him to, because I want to walk you through some stuff, and he knows this because we've practiced this. Bill, if you could do me a favor, scroll up for a second to the very top of your email. So the first thing I want to point out to you is that it's sent by my name, but it has this delivery. And this is a very common sort of spam virus thing where you'll see an email, and this is almost the dead giveaway, it's a virus, is it actually has a different sort of name. It says John Doe, and then it's Jimmy Fallon at CBS.com or something, and it's a spam from some sort of goofed up email. So that's the first thing, and some software may treat that as spam. We find a lot of times that people get these emails and they delete them as spam. We have to remind them not to delete them. We'll talk about that in a minute. So if you can go ahead and go down, Bill, and go ahead and you see it says it's been requested, and here's my language of here's the contract. He can view the status, or he can review and sign. And go ahead and review and sign. And this is what your client's going to get in a general situation. Remember our security, so Bill should be the only one with that security pen. He's going to put in 1, 2, 3, 4, which, by the way, is not a pen that I use with my clients. But and he goes confirm pen. And now it's going to bring you to the page. And you see, when we talked earlier, I told you that it was going to autofill the date. You can see I signed it on May 18th, Adam Spence, the trial lawyer. So now it's Bill's turn to sign. So he has a couple things. Bill, if you could click on actions for me, I want to show the reassignment feature. So go ahead and click reassign right there. So, and don't click reassign, but so what happens here is, so I've sent this to Bill Hall, and let's just pretend like Bill Hall is actually not signing, or maybe this isn't Bill Hall that got received it. Maybe this is Attorney Joe. So now he's going to put in Bill Hall's name and Bill Hall's email, and he's going to say, hey, here's that document that the opposing counsel sent. You need to sign this, Bill. So Bill would just put that in, click reassign, and it goes. And so the really important part about this is you cannot forward the email. It just doesn't work. It has to go through this reassignment process inside of the website, because if it doesn't, there would be no audit trail. It has to be reassigned so that the audit trail exists, because if he forwards it, it's just not going to work. I've never tried it, but it's not going to work, because I know the way the audit trails work, and they work by email. So you're going to click cancel on that, Bill. And now what he's going to do is, and by the way, you can't break this, right? So you know, say you're an attorney and you click start instead of reassign. So click start. And you're like, wait a minute, I'm not going to sign this. I need to go back to actions, and click actions for me. And you can still reassign as the attorney. So go ahead and click X on that, and then click next step. So you can read it, and you want to encourage them to read it, and click next steps there, that big orange button, which is convenient because it matches the colors of our brand. So click next step on the right. Oh, okay, and then click on sign. Okay, so he just clicked on sign, and he's going to pick his signature that he likes. Let me bring this over here to take a peek at this. Okay. And at this point, he's just going to sign it. And you'll notice the dates has occurred. And now go ahead and click on the initials and initial it. And we're almost done, folks. I know it's run over a little bit, but this is important stuff. And you click finish. Now, this is when we talk about those consumer disclosure. This is where you're going to see consumer disclosure. Do not sign it if you don't agree with it. Contact the sender. And then it says, by agreeing, you agree to be legally bound. And then that's where you go into the terms and conditions, which is going to include all those disclosures. And you click I agree. Okay. Now we had this happen before, where this happened, but what we found, Bill, if you can go back to your email, and we're not sure why we're getting this bug on this, but now Bill has already signed it. And we're not sure why we're getting that error message. We got that error message with him last time. My clients don't get that error message, but Bill, for some reason, what this does. And it may be because he's Apple. And so if you can go ahead, this is the email that Bill got after he signed the document. This email will also be emailed to me saying the same thing, and will be CC'd to Garrett saying the same thing. Go ahead and click on View Document, Bill. And again, protecting the identity and the privacy. And so now it brings you to this. And so Bill's going in there and he's going to say download document. And when that opens up, Bill, if you can go ahead and open up that document. Okay. So you remember we put the date up there. That's now inserted. Bill's signature is inserted with his dates. Both the dates are on there. Both signatures are on there. And Bill, scroll to the second page if that comes with it. Okay, that does not. What it does do, though, is it gives you a hashtag from EverSign at the bottom. And what I want to do is I do want to show you the audit trail. And am I presenting, Bill? I'm not sure if I'm.
No, you can start presenting now, though.
Okay. Okay. So what I did is I went back to EverSign and looked at this document on EverSign, and again, it looks the same as Bill's, but the critical part. It's going to make me monkey's uncle. I think Bill's Apple's messing with me. Yeah, this should be good. Here it is. And there's your audit trail. This is the really important part of e-signatures, is right here. So you can see I created it on this day. I signed it on this time and date, sent it here, and you've got your emails. And then it was completed on this date. And it has the hashtag on it, the document ID, and a fingerprint. So, and this matches that. So sort of the fingerprint. When we talked about digital certificates, that's effectively the fingerprint. So you're getting it's a little bit different, but it's not a digital certificate on my computer, but it's a digital certificate that's effectively being issued by EverSign on its website when you go there to sign it, and that's kind of how they work. So I would be comfortable as an attorney using this audit trail to to present this as a binding contract for the judge to get out the microscope to read the terms. And I think that's it. So hopefully you guys have learned a lot today. We've gone over our time, but if you'd like to spend a minute, I can answer some questions. And the first question I did want to answer, I'm already seeing one here, is are e-signatures binding and legal for waivers of liability? And would you recommend any specific language in the document? And actually, let me do this. I'm going to, hey, Bill, if you can take over presenting and go to the second to last slide. And then I'll stop sharing because I want to be able to face the screen while I look at this document. Yeah, they're absolutely binding for waivers of liability. That's why when you are going to ski at Ski Round Top, you can go online, you can log in, and you can basically sign a liability waiver online and click accept. I did this for my season pass to Round Top, Liberty, Whitetail, which I guess Whitetail is Maryland. So it is legally binding. Again, the specific language in the waiver is going to be the notice of terms, the acceptance of the clicking. Yes, I agree to do this electronically. Yes, I understand I have a right to refuse and to do this by ink. And just having those consumer disclosures is really what you're looking for from that perspective. And do we have any other questions?
No other questions so far, Adam.
Okay.
We can wait a moment if you'd like to see.
Sure, sure.
No other questions so far, Adam.
Okay. All right. It sounds good. All right. Well, I hope everybody enjoyed the talk and you learned something today. And get out there and start using your e-sign. Thanks, guys.